All rise.
Please, I can't see the judge. Please. As it pleases the court, Your Worship, no, my Lord, I'm appearing on behalf of the state.
Please, the court, my Lord, I confirm my appearance on behalf of number one.
Thank you, Mr. Gandani.
May it please this court, my lord, I confirm my appearance on behalf of accused 2, Mr.
Thank you.
May it please you, my lord, I confirm my appearance on behalf of accused number 3 and 6 in this matter.
3 and 6.
3 and 6, my lord.
Oh, yeah.
As the court pleases.
Yes.
As the court please, my lord, my name is Mr. Mwenda L. I'm appearing for the first time, instructed by Dinana Reed Attilis. For accused number 7.
Thank you.
As the court pleases, my lord, I appear on behalf of accused number 8 in this matter.
May it please the court, my Lord, I confirm my appearance on behalf of accused number 5 and accused number 9.
Yes, Ms. Bester. Oh, thank you, Mr. Tibo.
My Lord, the way I understand it, I was not here the previous time, but this matter is set down for a pre-trial.
Yes.
The state is ready to proceed with the trial, my Lord. So maybe that the legal representatives just can confirm whether they are ready to proceed and if they are placing proper funds.
Yes, the matter was inter alia postponed to give accused number 7 an opportunity to instruct a legal representative. Mr. Moilwa is here on behalf of accused number 7. And then I think Mr. Muriri also raised an issue the last time around. Maybe let's start with you, Mr. Muriri.
Mr. Court pleases, my lord. Indeed, so, my lord. Previously, we had indicated that there were undertakings that funds would be forthcoming. However, said undertakings have not been fulfilled. As things stand, my lord, I remain outside financial instructions, and this would then be my application that I withdraw as the legal representative on behalf of accused number 3 and 6 respectively.
So that is with regard to both your clients.
That is with regard to both my clients. Mr. Matswara and Mr.
Mahotsa. Yes, thank you, Mr. Mururi. Let me just hear from them. Mr. Matswara and Mr. Mahotsa. What is the position now? Mr. Mururi says that he has not received any financial instructions from you. Otherwise, you have not paid him.
That's all, however, we apply for
You will apply for legal aid. You're also going to apply for legal aid, rather. And you therefore don't have any objection if Mr. Mururi withdraws. Both of you. Thank you, Mr. Mururi. Your application is granted.
That's the court pleases, my lord.
Thank you. Yes, Mr. Moelo, on behalf of number 7.
As the court please, my lord. Indeed, as I've said, or as we've discussed in chambers, we have an instruction to move an application. Unfortunately, I just got failed by my device here and I'm informed that there are no plugs that are closed. It's unfortunate. This is like 2024. But we find ourselves in this situation. So I'll just work around with what I have and rely on my memory.
Yes.
Yes, we rely on these devices. So the application that we're going to move, my lord, it's literally to safeguard the interest of accused number 7 which is primarily the right to have legal representation. So without that right, nothing can move. Trial or pre-trial, absolutely nothing can move. Because our responsibility, we don't owe him only the responsibility to protect his interest, but we also owe the responsibility to this court as officer of the court for the administration of justice. So that's why that aspect should be moved first before anything else. And as such, the accused previously tried to move this application. Last time, there was something, obviously, it excited the media. But in that endeavor, he was simply saying, my Lord, I can't do anything without consulting with my lawyers. And possibly, in the treatment that I'm receiving, you might not have accused number 7 in the future. Either because of psychological problems, because we need him, all of him, physical, mental, everything. So if he is kept by the state machinery, which is the correctional service, in the manner that obviously I'm not going to deliberate, it's there in the papers, it's going to be deliberated in due course, would have wished to deliberate today. We might not have him mentally intact. So, and that itself, my Lord, it's something that needs to be dealt with expediently. And we also responded to that expedient, to that expedient requirement of that type of endeavor. So what we did, we consulted with him several times with the restriction that are imposed by the correctional service, and some of the restriction obviously ended up in some of us catching food because we consulted in extremely cold conditions there at the correctional service center. So we don't want to have him not here in court and his legal representative because of the conditions there. So we drafted an application, founding affidavit, served on the state, served on the prosecutor, served on the correctional service, served on the head of correctional service, because some of the prayers that we seek, it will need the court to order them to do or not to do certain things. Now, what happened in Chambers was some sort of like an engagement as to whether this court would hear this application or it should go to some court, motion court or whatever court that specializes in that. Our view is that this is the court that specializes in what we are about to do. Because it has nothing to do with anything else but his right to a fair trial. And a fair trial is not him taking the stand and start giving testimony. Fair trial includes legal representations. So if that is threatened or has been violated, this court itself must intervene. That's why this court can intervene that now the correctional service, as they are here, because this is not Postponement, it is the court, can order them to remove the shackles. He is in shackles now. As you see him as a criminal, but no, he's not. He's an accused person. He must enjoy the presumption of innocence. So when you see someone being brought like this in court, you have the impression that here is a villain in court. We don't want that. We want your lordship to see him as all other accused that you see here. So that on its own does not need some head of correctional service. He is before your lordship, that you can do. Does not need us to go to any other court. Literally, your lordship, with utmost respect, can say that this creates a bad perception to the accused person, that there is accused person that are seen as criminals, there is accused person that are seen as accused in a true sense. So that is part and parcel of what is going to be the motivation. Why no any other court but this one must hear this application? But because, my Lord, administratively we had challenges that we could only serve this application yesterday at 3. What that means is that inevitably, even if your lordship wanted to get this application, it's practically impossible. because we raise serious issues, legal points that need to be ventilated. And that's why in the service of the application, we omitted a notice of application or a notice of motion deliberately, in the sense that there was no one that would have been able to come here. But as a matter of courtesy and to avoid ambush, serve the affidavit, and we say that in our notice of application, we will obviously seek directives. If we had enough opportunity to deal with this application, we would have prescribed the time frame, because there's no rule in this particular court that says that this one must file the application after 10 days. It's not Rule 612. That's not how criminal proceedings are conducted. Try to fashion or find the best possible solution under the circumstances to protect the right of the accused. You don't become the slave of the rules that are not applicable. So we would have prescribed and motivate why we prescribe as such. But because time did not allow, he then says that we will try to put it before the court and seek directive that other parties that are not here, how can we possibly remedy this and prescribe the time frame that would, in light of the circumstances, ameliorate the prejudice that is suffering. Because now, if we then say that let's go with what it's done in the motion court and prescribe those time frame, it defeats the purpose of what I've said. We're going to come with a person who's mentally short, or physically or otherwise. So that's why exonerate himself. It could be that the truth is to implicate himself, but it must happen now. It must not wait for a future event and allow the violations to happen. So I did not want to say this, but because there was that pre-engagement in chambers, I spoke to the accused and I was instructed as such that I must place this on record, that their instruction and indeed the legal advice is to have this application had. If there are any challenges, or legal variances, this can be ventilated. So my suggestion would be that if there's any legal variance, the ventilation of such can be decided, the date of ventilation of such can be decided by this court. Because this court cannot decide that I'm not hearing the application because there's a particular heading in that application. He must hear the substance of that application to make a determination that go to a tax court, go to this particular court. It must.
Why a tax court?
In my previous life, I was doing tax law.
Well, let's stick to your current life. Let's stick to your current life in criminal court.
Just give you an example of other, but the point that I'm making, my lord,
Yeah.
and let me just say these proceedings are serious. The point that I'm making is that the court must, at least this particular court, hear the basis thereof and allow every party. It can even say that before I decide whether I want to hear it, I'm calling parties specifically to deal with this particular aspect. That's what I wanted to say, and then if there's anything else we hear. But in respect of then, thereafter, because your lordship also mentioned the issue of time frame, that there are other matters, we should try to limit lengthy engagement so that your lordship can proceed. Is that after this, we've informed our clients that we're going to consult with him. And let me start by saying that in that respect, we're indebted to your lordship for intervention. For the very first time, I met my client for the very first time. In Hosimampura, I was meeting him behind glass and telephone and stuff like that. This is the consultation that we envisage. And I hope that after this court, we're going to get more information so that we can move forward. So that is going to happen after the postponement of this. But my request is that we be given an opportunity to argue this particular point of jurisdiction after your lordship has considered the best possible way that it can be done.
Yes, Mr. Moela, obviously I do not know what the basis of the application is because I have not been privy to the papers. Ms. Bester has already indicated in chambers that they are going to oppose the application, and they have not yet filed any answer to the paper. So let's hear Ms. Bester.
My Lord, if I may. First of all, my colleague is a junior colleague, and as far as I know, he was supposed to put it on record because Mr. Miche, senior counsel, phoned me yesterday and also about 3 weeks ago that he's going to appear for him. So if my learned colleague didn't see him, Mr. Bester, then I can understand why he wants to do it today. First of all, I want to answer on that. The state is the prosecutor. I'm presenting the state. So he can't serve it on the prosecutor and the state. Nothing was served on us yet. The documentation that I received yesterday by means of an email was unsigned affidavit, and I was informed via email by Ms. Denana Reid that they will serve the papers today. That is an application, a motion application. There are certain rules for that. We cannot hear the application today because according to that unsigned paper, correctional services are cited, CMAX are cited, and I think the Minister of Police. So the audi et alteram partem rule is applicable not only to the accused but also to the rest of the parties. And with all due respect, my impression is that my learned colleague does not understand the difference between an application for notice of motion and what he wants to do now. This is really not the way he's supposed to do it. Then he must make his mind up what is he going to do. But we can't do it like that. Then, my Lord, it's not only accused number 7 who's got certain rights. Accused number 1 is in custody. The other accused are there. I understand from my learned colleague, Mr. Mashini, they are ready to proceed with trial. But the state is also entitled to say that we are also ready to trial. And we are ready for trial since last year, October. And then what they didn't put on the
But
record.
do they receive similar treatment at the respective prisons? I know she is at Kroonstad, he is at Jose Mampuru.
But the women are in Kroonstad.
Yeah.
And we cannot interfere as to where they must be kept. I mean,
No,
that
not
is-
where
that
they
is-
are kept, but I think Mr. Moela is referring to access to his client.
My Lord, I
That's why I'm
cannot...
asking you, is there a situation of accused number 1 being treated differently to accused number 7, since you refer to accused number 1?
Then the correctional services must answer to that. I'm not a party to that. Really, I can't answer on their behalf. But what they didn't put on record, I received also Friday another application that was brought by the accused in person, that he was abducted from Tanzania and so forth. I didn't mention it now. Mr. Miche informed me that they're not going to handle that. He's going to do it in person. Because really, we must start to move on and proceed with this matter, because this is in everybody's interest that we can proceed with this matter. Thank you, my Lord.
Mr. Moela, I heard you referring to jurisdiction. Now I hear Ms. Bester also referring to jurisdiction in a roundabout way. Are you saying that the application that you want to move relates to the jurisdiction of this court to try accused number 7? Or what is it?
Yes, my
Because
Lord.
that you can do at plea stage.
Yes.
The Criminal Procedure Act makes provision for that.
Yes, my Lord. When we prepare this application, let me just say that it's informed by research. That's first thing. And what is going to speak there, it's the case law more than my voice. Obviously, the case law is written. I must be the one reading it. But literally, this is not the first case, and it's not going to be the last case to hear this application in a criminal court. There's a plethora of case law in that respect. And in no
Yes.
way did I stand here and I said I want to argue the application. It would be absurd for me not to give an argue. I mean, every law student, even the one that are just studying certificate in law, they know that the outer principle is the foundational value of our constitution. I can't move an application without giving people an audio. What I said is the pre-engagement that we had in chambers, that after having consulted with my client, that this is then the instruction. So the issue of jurisdiction, I even suggested, gave the solution. I don't understand whether there's going to be selective listening and selective answering. I gave a solution that we can come and argue this particular point. And truly speaking, I don't know how it's going to be defeated in the respect of jurisdiction. It might be defeated in merits, but in jurisdiction, my lord, I can literally, on the day, take less than 5 minutes to deal with this point. If it can be argued now, it can be argued now.
I prefer not,
Yes.
because the people that I'm told you have cited or institutions are not before me yet.
Yes.
And I would like to hear what they have to say about your application. The prosecutrix informs me that she has received the papers yesterday. She says it's a notice of motion, but they have not yet answered. I'm told that the Department of Correctional Services, Minister of Police, and the Commissioner are also cited, but I don't even know whether the papers were served on them. So, for all intents and purposes, Mr. Moela, that application is not before me. Let us wait for them to answer and for you to reply, and a court date will be allocated for the matter to be ventilated. So, for all intents and purposes, now where we are, there is no application before me. I have not seen your papers, and I'm not interested in seeing them now until after all sets of affidavits have been filed by all people who have a material interest in the matter. You indicated to me that you want an opportunity to consult with your client, which opportunity I gave you. And you also intimated that you might request that the matter be postponed to sometime maybe in next week or so. I would want to hear from you now, when it comes to the postponement, what is the situation? Whether Mr. Mshe will be arguing the application or whether he will be conducting the trial on behalf of accused number 7 is at this stage neither here nor there when it comes to these proceedings. You are satisfied that in order to protect your client's rights, you have consulted with him, and if not, I will give you another opportunity to consult with him in the cells after I've postponed the matter. We have facilities for that. You can consult with him. Is there anything else?
Yes, well, I mean, that you're looking for commenting on that aspect of SC, I don't understand how it featured, it found its way, but it's irrelevant for what I said and what I'm going to say.
I agree with you on that score.
Yes.
Yes.
So in respect of the postponement, it was predicated on what I said, that because the application, because obviously I think I just need to say this for less than 2 minutes. Because of the challenges that we've been having, each and every time we request a consultation, we are given a maximum of 2 hours, and in those 2 hours we must gather the information, write notes, and under difficult circumstances. So after having set up plethora of consultation, we finalized the application. Now, it would have been served by at least Monday under the circumstances, because sometimes we were even told by the correctional service that they did us a huge favor by giving us 3 days, that's 6 hours, because other inmates could not. So that means our consultation are also dependent or at the whims of correctional service. So after having that done, after having done that, finalized the application on Friday, for it to be commissioned, we had to ask for an urgent consultation, which was only granted yesterday. That's the reason why this application is then commissioned and filed on the 11th, not filed, served on the 11th hour, because it was served on other parties, but what was not served is the prescription of timeline. And that's what we said. We're going to seek directives from this court. But from what I understand, the court is saying, Mr. Moela, go and prescribe the time.
Yes, Mr. Moela, if you bring it on an urgent basis, you can prescribe the timelines. If you bring it in the ordinary course, the rules prescribe that. It's not for me to prescribe how you should bring your notice of motion. So let me make the following suggestion, Mr. Moreno. Don't you want to rather consult with your client fully today? Decide whether you're going to move your application and in what form you're going to move it. Either from the bar or whether you're going to proceed by way of notice of motion, because I hear you saying it's not a notice of motion. So do that. It seems to me at this stage that the matter is in any event not ripe for trial, because we have the issue of accused numbers 3 and 6 who want to apply for legal aid. So they must first be assessed in order to see whether they meet the means test. And should they meet the means test, legal aid will either have one of their practitioners appear on their behalf or more practitioners, or they will appoint judicial legal representatives. That gives you more time to settle your application and make sure that everything that has to be done is done. And it might be a very short postponement, but at least it will give you time to consider your next step. Will that be fine with you?
Yes, with modification, my lord.
Yes.
The application is ready, and all this point that your lordship is posing.
But it can't be ready, applications can't be ready if there's no answering papers, if it has not been served. Then it's not ready.
I'm talking about from my side, our side, then our papers are in order. In other words, there's no further instruction in respect of finalizing the papers. That's not that the application is ready for hearing. What I'm talking about is that the application from the accused point of view.
So you need to consult with him with regard to the application.
No, the consultation,
because it's done.
The consultation is just the right to consult, because now he's charged and then this matter is pending. So because now it's brought before this court.
Let's do it one step at a time.
Yes.
For the application that you desire to move, you have consulted, the founding affidavit is complete, you don't need to consult about that application.
Yes.
Good. The consultation that you are referring to are the consultations with regard to the trial of the matter.
Yes. Thank you, my lord.
Yes, now let's deal with the application. You will then serve the application on all those cited, and if they are so advised, they may file their answering affidavits. You will reply at the opportune time, and obviously you will need time to consult with your client. That is something else. Now let's get back to the pre-trial proceedings. Accused number 3 and 6 currently do not have legal representation. I am minded and inclined to give them an opportunity to apply to the Legal Aid, to Legal Aid South Africa, for Legal Aid South Africa to appoint attorneys or legal representatives to appear on their behalf if they qualify at this stage. That postponement will be, depending on what the other parties are saying, will be a very short postponement. That is normally how it is done in this division, so that they get legal representation. The legal representatives will consult with them and indicate whether they are trial ready. So for now, Mr. Moela, unless there's anything else that you want to add, I want to turn my attention to the other accused persons.
Nothing, my lord.
Nothing.
But nothing.
No, if you say nothing but, then there is something.
Okay, I don't want to waste those time, my lord. But, I don't want to.
No, it's fine. I have the time. I've dealt with the pre-trials before we called this case.
Thank you, my lord. I've been speaking with so much speed. I'm normally a calm person. So
Take your time.
we need that consultation, because sometimes I've been told by the accused that immediately when the court adjourns, they take him. But if your lordship could clarify that his hours is before your lordship.
How much time do you need?
Would need him till the end of business day.
But you understand that there might be practical problems with that. He must still be transported to Pretoria, I think, is where the prison is, where he is kept.
Yes, but my lord.
Let's settle it this way. You and Advocate Bester will please come and see me in chambers after the matter has been postponed. I will request the police officers as well as members of correctional services not to remove your client now or after the postponement, pending the agreement and arrangement reached between the two of you in chambers, which will then be communicated to them. But I think we should please try and be reasonable. If he is kept here until the end of the day and he must still be transported to Pretoria, there might be some practical problems involved. So let's try and keep it within reason. We will postpone, I'll postpone the matter. You and Ms. Bester can then come and see me in chambers.
As it pleases the court.
Just confirm if everything
Yes, yes.
Yeah, no, they're not. They will.
There are two issues that I also said.
Yes.
But is that problem that now I've shifted from my device to this regime?
No problem.
One, these are just security issues that are happening now. There is a Mr. Maswangani that I'm informed that he's the head of EST and that he's been making the life difficult for my client in the consultation cells. In other words, even where the accused person, as he informs me this morning, that he was allowed, but he was advised by the head of prison, Mr. Kabengo, from Correctional Service, Postponement, that he can consult with the co-accused as long as they are his witness. And he was told that there's nothing stopping him from that, but when he got here, this Mr. Masongani then specifically says that there must be a court order to that effect.
No, but Mr. Moela, look, I think we are now going around in circles. Earlier this morning in my chambers when you and Ms. Bester were there, you asked me for time to consult with your client and you did consult with him. So I don't understand your argument now with regard to the various or challenges for you to consult with him. You did it this morning right here in the court cells. I can see no impediment why you can't do the same within reasonable limits, of course, after the matter has been postponed. But as I said, between you, Ms. Bester, and I, that matter can be resolved.
I accept that aspect, but it's one of the instructions that I'd forgotten. But because of the much needed intervention from your lordship, I think that is the best under the circumstance.
Yes.
Let's try to resolve it together with the issue of having him until, because it's part and parcel of the consultation.
Yes.
In that respect, my lord, I don't think that I have anything to say.
Yes, that is. Thank you, Mr. Moela. Mr. Dlamini, we now have Mr. Mururi's clients, 3 and 6, accused numbers 3 and 6, who do not have any legal representation. I intend to postpone the matter for a week or so in order to sort that out.
My lord, I I guess we don't have an option. We are bound to adhere to their request to be afforded an opportunity to have their legal representation. However, my lord, there are two aspects which I also wish to place it on record. My lord will remember that on the previous appearance, I raised the issue with regard to the incompleteness of the indictment.
Yes.
And my lord made an order that the state should provide the defense with a completed indictment within 7 working days. That has been complied with.
Not been complied with.
It has been complied.
It has been.
It
Okay.
has been complied.
Fine, yes.
And secondly, my lord, there was an issue with regard to our reply to notice in terms of section 212B. We are certain that it was served and filed on the 19th day of February 2024. We've got a copy thereof, and if it is not in the court's file, my lord, we are more than willing to make a copy available.
Okay, fine. That is only with regard to accused number 1.
That is only in
Yes,
relation
no,
to
it's fine.
case number 1.
Yeah.
Yes, my lord. And as far as that is concerned, that will be all from our side.
Thank you. Mr. Mohamedi, for accused number 2.
Thank you, my lord. My lord, I'm also of the view that seeing that we are also on legal aid, we won't have instructions, and so we won't have an objection to accede to the request by accused 3 and 6 to have their legal representatives.
Thank you. Mr. Diba.
No objection, my lord.
Thank you. Ms. Creer, you are legal aid. They
I
will
am legal
probably
aid
come
indeed,
to
my
you.
lord.
Yes.
My lord, no, with regards to the current accused, we have no objection, and then obviously we will then take down the necessary applications on behalf of accused number 3 and 6, my lord, to evaluate the position. as it pleases the court.
Do you want me to request them to come to your offices today still, or
Yes, thank you, my lord. I will also speak to them now after the adjournment.
you'll
but
then speak to them?
yes,
Okay.
thank you, my lord.
Fine, thank you. Mr. Mutloum?
No objection.
No objection. Look, we normally do pre-trials on a Wednesday, and next week Wednesday would be the 31st?
Don't ask me now, that, my lord, I
I
can't
think
remember.
so. If today is the 24th,
Yeah.
plus 7 will be, yeah, the 31st. Does the date suit everybody?
I'm available.
You're available? Or let me ask it rather in the negative. Who will not be or cannot be available on the 31st of July? Nobody.
Next week, Wednesday.
Good. All right, the matter is then postponed to the 31st of July. The situation of the accused is accused number 1 and 7 are in custody. Who else, Ms. Bester?
Accused number 1 and accused number 5. They're in custody. And
1, 5
accused
and
number
7.
8. Moyo. Mr. Moyo. I think
No,
he's
but
accused number 8.
Moyos, Mr. Kloum's client, eh? Yeah,
Indeed so, my lord.
good. Yes, accused numbers 1, 5, 7, and 8 in custody. The rest bail is extended, warned to be at this court again, the morning at 9 o'clock. Thank you.
As it pleases the court.
Is that the
As it pleases the
roll?
court, my lord.
Thank you, the court adjourns.